Thank you all for joining us. My name is John Champ. I'm a senior planner with the city of Dana Point. I appreciate your attendance this afternoon and going over some information related to short-term rental regulations for homeowners associations in the coastal zone. Before we start, I just want to let everybody know that the meeting is going to be recorded. So we're going to be posting it to the city's website on our short-term rental page for any HOA representatives or anyone else that wasn't able to participate in the meeting. And so just a quick summary of the agenda for our discussions today is to give everyone a little bit of background about the recent short-term rental regulations that were approved by the city in the coastal zone, as well as the city's available streamlined coastal development permit for those HOAs in the coastal zone, and what that application submittal items include, as well as go through a quick timeline in terms of next steps, and then answer any questions that anyone has. So I'm going to ask that everybody remain muted, and then at the end, when we're on the Q&A, you can use the feature to raise your hand, and we'll be calling on you to answer any of your questions. So with that, I'll be proceeding with the meeting. So in November of 2022, so just a few months ago, the city did obtain approval from the Coastal Commission, a short-term rental program to issue new short-term rental permits in the coastal zone, as well as new modified regulations for those short-term rentals. So we've got a slide here. Bear with me. Let's see, that's not going. Hold on. There we go. So here is just a very brief summary of the short-term rental regulations for the coastal zone associated with permit caps and what's allowed. So it establishes an overall cap of 115 permits, and that applies to non-primary, which is your traditional short-term rental where no owners on site and it's rented an unlimited number of days a year. Then multifamily homestay, which is you're a property owner, that's your primary residence, and let's say you own a duplex or a triplex, and you rent out one of the other units as a short-term rental. And then mixed use parcel, which is essentially you own a property within a mixed use zone in the city and you rent that as a short-term rental. So there are no caps for the homestay and primary residence types of short-term rentals, which the homestay is if you have a house and you rent it's your primary residence and you rent a room for a short-term period, which is short-term is anything less than 30 days. And then primary residence short-term rental, which is you live there, it's your primary residence, and you maybe you're a teacher or you travel a couple of months out of the year and you want to get some additional income, and so you rent it for up to 60 total days a year. The cap does get adjusted depending on the number of homestay and primary permits that are issued. So every time one of those types is issued, the overall cap drops by 1. So in terms of existing permits, we have 69 now, which offers an availability for an additional 46 within the coastal zone only. As part of the application process, which we're going to be discussing tomorrow and have a link on our website, the city will be requesting a letter from the homeowners association that clarifies that the short-term rental is authorized in their community. So for those HOAs that allow it, then they would be providing a short-term rental permit. So the city does want to honor the desires of each of the communities, whether they want to prohibit it or allow it in terms of the associations. And so with that, in processing the coastal development permit with the Coastal Commission had identified some recent court cases, which are Greenfield versus Mandalay Shores Community Association and Crack versus the city of Santa Barbara, which determined that if an HOA wants to deny a short-term rental permit, then those prohibitions on short-term rentals need to be incorporated into their CCNRs or other regulations prior to 1976, or they have to obtain a coastal development permit to authorize the ban. So this is legal analysis that was completed by the Coastal Commission as well as the city's attorney, but we do recommend that you obtain your own legal opinion if you deem that necessary. Again, the city wants to bolster your regulations within your communities, and continue the desires of and protect those. So if you want to allow short-term rental permits, you don't need to do anything. However, if you want to continue to prohibit short-term rentals, then the city is recommending that you obtain a coastal development permit to avoid any future potential conflicts with any residents in your community that may be looking for a short-term rental permit. However, I do want to echo that, again, as part of the application process, we will be requesting a letter from the Homeowners Association authorizing a property to operate as a short-term rental within their association. So going on the next slide here, I want to just illustrate here, illustrate the city. Here we've got an overall map of the city. The city's boundary is reflective of the yellow line that meanders throughout the map. And then the thick blue line that meanders through the map is the city's coastal zone. So it's not a uniform line. It doesn't follow any particular topographical or distance measures. It does meander for a number of different reasons, and was established when the Coastal Act was established. So there are several communities that are located wholly within the coastal zone, or are split and are partially in or partially out of the coastal zone. And so any communities that would be located within or a portion of the coastal zone, we would encourage to and want to prohibit short-term rentals. We would encourage you to obtain a short-term rental permit, or I'm sorry, a coastal development permit for the prohibition of short-term rentals. This shaded blue area here along the coast illustrates the appeals jurisdiction within the city's coastal zone. So this is an area that's also within the coastal zone. However, coastal development permits approved in these areas are subject to appeal to the Coastal Commission. So we can discuss that at a later in the presentation. So I wanted to go over the city's proposed streamlined coastal development permit process, and this includes a reduced application. It's really a one-page application. There's very minimal submittal items because the city wants to make this as streamlined and as effortless as possible for the associations to process. So the city is also proposing a reduced fee that is going to be reviewed by the city council, and we're anticipating them making a decision on that on their March 7th meeting. So we don't have that fee yet, but it's looking like it's going to be a couple $100 per association. So again, if you are in a community where you already allow or are considering or want to allow short-term rentals, then this coastal development permit process is not applicable, and you don't need to proceed with the coastal development permit application. So quick summary of the information necessary for the application here listed on your screen is really any applicant agent information. Ideally, it's an HOA board member representative or property management representative, as well as an alternative contact person if necessary. Submittal items, we're looking for the number of residential units in the community, as well as just the year the CCNRs were established. And then a letter from the HOA board authorizing the submittal of the coastal development permit application for prohibition of short-term rentals in your community. So let's see. And then the page 2 of the application is the notice of pending coastal development permit This is just a form that just these couple of lines get filled out here: the location, the applicant name, application number, which we can provide to you, and the dates notice was posted. This is required to be posted on the property. It can be posted anywhere on the property. Ideal locations would be if you have like a community message board or something like that in a common area. So I'd like to kind of go over the next steps. Applications can be submitted for those associations that want to proceed with this as soon as March 8th, being that March 7th, the fee will be established. However, we will have a number for the recommendation for what that fee will be probably in the next week or so. So if you are interested, you can you'll have that information here shortly. Then really what we're looking for is to process the applications as soon as on April 24th to the Planning Commission, who is the review authority for these coastal development permits. And then there is an appeal period with the city of 15 calendar days. And for those associations that are located within the Coastal Commission appeals jurisdiction, there's an additional appeal period following that initial 15 calendar days of 10 business days with the Coastal Commission. So really you're looking at about a total of 30 days in total of an appeal period before the decision is totally final. However, if you're located out of the appeals jurisdiction, the appeal period would just be those 15 days. So with that, we do want to open it up for any of you that would like to have any questions answered about the process or anything else regarding that. So if you want, you can, if you click on the reactions button at the bottom, and you can click on raise hand, and I'll just be calling you. Does anyone have any questions? I see Nancy. Nancy, I'm going to ask you to unmute.
Hi. Okay, so I do have a couple questions. Will the application be online by March 8th then?
Yeah, I think the application, if it's not already up online, it'll be up before the end of the day. So yes.
Okay, and is the map online? Because when I tried to access it about a week or so ago, it wouldn't take me to a page. Is the coastal map up and accessible?
Yeah, we can provide an additional link to it, a little bit more user friendly to get to it. There's several maps. One is just a map citywide. Another one is searchable by address. So
okay.
Absolutely include another link so everybody kind of see where they're at.
Okay, and then hopefully last question is, so the city is requiring a letter from the HOA authorizing the STR. If the HOA hasn't obtained a Coastal Commission permit and submits a letter saying that the STR is not approved, what does the city do?
So the city's going to honor the HOA's position in terms of short-term rentals, but is going to be encouraging the association to process that coastal development permit to avoid any issues between the property owner, community member, and the homeowners association.
Okay, so the STR application is actually approved by the city. Is that what I'm to understand? Not the Coastal Commission?
Correct.
It is, okay. Unless you're within that appeal area, then it has to be appealed to the Coastal Commission.
So the city is issuing all of the short-term rental permits. The city is also issuing the HOA coastal development permit to prohibit short-term rentals. If that coastal development permit for an HOA to prohibit short-term rentals can be subject to appeal to the Coastal Commission. However, the short-term rental permit cannot be appealed to the Coastal Commission.
Okay, so the permit, the application for the STR coastal development permit is approved by the city. There's a 15-day appeal process. And who has the right of appeal? Anyone in the HOA or anyone in the area, the Coastal Commission?
Yeah, the Coastal Commission could appeal it, or a member of your community could appeal it, or a member of the public technically could appeal it.
Okay, so
this is Brenda. I'm the community development director for the city. I think you might have some confusion.
Okay.
There's two things that are happening. One are short-term rental permits. And those are applications that the city would be receiving from a property owner. And those will be accepted probably later in the spring. What we're talking about this meeting are the coastal development permits. The city will be accepting applications for HOAs to request a prohibition on short-term rentals.
Right, and so once we go, and so for the HOA to get the coastal development permit, is that the area that's subject to the appeal?
Yes, areas that are in the appeal zone are subject to appeal.
Okay, and so anyone can appeal, though, the grant from the city of the coastal development permit?
Correct.
Correct, okay. And then there's an additional time for the Coastal Commission appeal, and that's, again, anyone can appeal during that extended period. It's not just the Coastal Commission.
Correct.
Okay. And how long will the application process take, do you think, through the city?
I'll turn it back over to John. Sorry, John.
Yeah, so we're anticipating applications to be available as soon as March 8th, or submitted. Sorry.
Right.
They can be submitted as soon as March 8th, and we're anticipating getting it to hearing as soon as the April 24th Planning Commission meeting. So we're going to bundle, depending on how many we get, we're going to bundle as many as we get and get them to that first hearing. So because there is a noticing requirement associated with this, that it be noticed about 14 days prior to the hearing, we're looking at about more or less a 40-day period from submittal of the application to the Planning Commission hearing.
Okay. All right. Thank you.
Good questions. Thank you. Stephen Moss. Sorry, Stephen, I got you. There you go.
Am I unmuted? Thank you. Thank you so much. Yeah, one of my questions was that appeal process. So thank you for the previous person asking. I've got a question. It almost sounds, when you talk about allowing short-term rentals, it's like black and white. Kind of the HOA either does or doesn't. Now, what if our HOA, limits short-term rentals if they're less than 30 days? I mean, you can only do a short-term rental if it's more than 30 days. And that's in our CC&Rs. So what would be your guidance in terms of getting a CDP?
So just to clarify with you, did you say that your association only allows for rentals if they're 30 days or more?
Correct. You can't do a daily or a weekly rental. It's got to be more. You can start at 31 days or longer as a short-term rental.
The city considers a short-term rental anything less than 30 days. So my understanding, based on what you're saying, is that your association would not allow short-term rentals. So if you want to do rentals 30 days or longer, you don't need to do a thing in terms of, they don't need a short-term rental permit.
Mm-hmm.
Now, if your CC&Rs were not established with the prohibition prior to 1976, which my guess is most all are that case, we would encourage your association to process a coastal development permit to reinforce your prohibition of short-term rentals.
Thank you, John. That's exactly right. I thought, because my follow-on question was what kind of legal exposure, well, we won't talk legal because I'm not an attorney. I don't know if you are, but what kind of exposure or protection does the CDP coastal development permit provide the HOA? Because we sure would, we don't want to, we're not looking for exposure from, homeowners who want to start a business.
Correct.
So
that would close that exposure.
It reduces the exposure. Okay, going forward. Perfect. John, so if I'm understanding, to reduce our potential exposure as an HOA, we would be advised to put in through the CDP process.
Correct.
Great. That makes sense. Thank you. That was my question.
All right. I see Janet. So I'm going to ask you to unmute.
Okay. So now that we've figured that out with Joan, because we're in the same HOA, we have to fill out the CDP in order to prohibit short-term rentals under 30 days, even though it's in our CC&Rs already?
So the city is encouraging associations in your boat to process the coastal development permit, given that these recent court cases say that any communities that are within the coastal zone to legally prohibit this, and your CC&Rs were not established with this prohibition specifically prior to 1976,
right?
And you don't have a coastal development permit, that this is the route you need to go to do that. So we're encouraging that.
So how will those be policed or enforced? Is that up to the HOAs to not allow the homeowner to do that, or is that a city?
So as far as it's a little bit of two things that are somewhat connected. One is the HOAs, and we're encouraging the coastal development permit for the prohibition. And then the other is that a resident of your association that wants to obtain a short-term rental permit, we're going to be asking them for a letter from your association. So without the letter, we're not going to give it to them. But as the speaker before you, this coastal development permit prohibiting the access will, limit your exposure here on this issue with your resident.
So is that a one-time permit? Because it's a pretty hefty fee for a permit. Or how long does that permit last?
It's a one-time permit. It would last forever.
Okay, cool. All right, thanks.
But also, Janet, I'm not sure if you heard John say, but the city council is going to be looking at modifying the coastal development permit fee on March 7th. So, the fee could be as just a few $100s.
Okay, cool. That'd be good. All right, thank you.
Next, I'm going to ask Dee to unmute yourself. Dee, are you there?
Yeah, I'm here. Can you hear me?
Yes, I can.
Oh, thank you. I wanted just a little more clarification. Am I understanding that the CDP will only give so many permits out? And if that's true, what if we don't get one? What if we don't get it in time and they say that's all the permits we're going to deny or approve? Am I looking at that incorrectly?
So Dee, just to help better understand your question, is this
in an HOA? Yeah, I'm in an HOA.
But are you looking for a short-term rental permit? Or
no, we do not want a short-term rental, and we wanted to apply for the CDP. But I'm just wondering, do they run out of permits? And then what do you do if they only give so many out? I was understanding you're only going to give 64 or something like that. Am I incorrect?
So there is no limit on the number of coastal development permits that can be issued to homeowners associations to prohibit short-term rentals.
Okay, great. Thank you. Okay. Just wanted to make sure.
No problem.
Thank you.
Okay. Marla, I'm going to lower your hand and ask you to unmute.
Okay, my question is, what are, I understand that CDP and our original CCNRs were recorded in, the original was recorded in 79, but then we had the 30-day thing was recorded in 91. So I'm assuming that won't stand up due to the 76. Actually, our original CCNRs were 69, sorry. So we would need to, in order to protect us, we would need to obtain a CDP. And my question is, what is the likelihood that the CDP would be approved? Is there any, I mean, these are brand new and you're just starting this with HOAs. Is it pretty likely, 50%, 70%, 10% likely that they'll get approved?
I've had several conversations with the Coastal Commission staff about, the necessary process, and they honestly don't want to insert themselves into, whether associations, want to prohibit or want to allow. They want the community to figure that out. And okay. So it's my feeling that it's very likely that the Coastal Commission is not going to be in opposition to any of these coastal development permits. However, they want this prohibition of short-term rentals to be legal per their terminology. And so to bolster your prohibitions, this is the best course of action. And the city feels like during our short-term rental review process with the Coastal Commission, they looked at everything the city has to offer in terms of overnight accommodations and compliance with the Coastal Act and a lot of key factors. And they felt that the mixed amenities that the city provides is very favorable in a community such as ours and in compliance with the Coastal Act. And so I don't think that the Coastal Commission staffers are gonna have any opposition to these requested coastal development permits.
So because we have half of our community in the coastal zone, you don't think that there would be an appeal, or chances are slim that there would be an appeal?
So there could be an appeal from one of your residents, I guess, but
right.
Ultimately, I don't think that there will be an appeal from the Coastal Commission itself.
Okay, thank you.
You're welcome. Joseph, I see you up here. I'm going to ask you to unmute.
Okay, John. Actually, Marla's question was very helpful because I had that on my list in terms of the likelihood of these CDPs passing. When you spoke earlier, you discussed there were certain areas within the coastal zone that you described as areas of appeal. Is that correct?
Correct. So I'll share my screen again and bring that up just for context of your question. Bear with me a moment. Let's see here. All right, so can you see that map up?
Yeah, I see it.
So that shaded blue-green is what they call the Coastal Commission appeals jurisdiction. So any communities located within there or partially located within there could be subject to an appeal to the Coastal Commission, either by a coastal commissioner or, a member of the public or a member of your community.
Got it. So if I'm looking to my left, the Salt Creek area, the dividing line, is that PCH?
Yes, for a majority of that, you're correct.
Okay, got it. Okay, John, that's answered my question.
All right. So I see Paul. I'm going to ask you to unmute.
Yes, Paul Jacobs, Monarch Beach Master. So I don't want to ask you to get too deep in the weeds here, but I wonder how the city would respond to this. So if we have a master association and we have sub-associations, but the master association has really jurisdiction over our main artery and the gates. Sub-associations control their own turfs in their own geographic areas. So suppose we had a situation where Monarch Beach Master would file for a CDP and most of our sub-associations would also file. But there was one, for example, that did not file that actually wanted to have short-term rentals. How would the city view that conflict of interest there?
So Brenda, jump in if I'm incorrect in stating this, but my assumption is that, like you said, that there's sub-associations which govern their own neighborhood. And we do have one community in this particular area. I think it's Monarch Hills in the Corniche area that allow short-term rentals. So basically, we would be looking for a letter from that particular community of authorization to operate a short-term rental.
Yeah, okay. Well, perhaps I should take this up with our own council. But I appreciate your answer. Thank you.
Certainly.
Hey, John, I've had my hand up for a while. Just, I don't know if you see me up there in the corner. George,
I see you. Go for it.
Yeah. So just follow on to Paul's question. In the event that a sub-association doesn't have a 30-day, provision in their CC&Rs, and we apply for a prohibition, a CDP, would that be sufficient, or do we have to go back and modify the CC&Rs for that less than 30-day provision?
So as far as the city is concerned, the processing of the CC&Rs we would deem acceptable. We probably recommend for your own, liability. I refer to your attorney representing your community as far as whether the CC&R should be updated or not. Mm-hmm. And then also, as I said throughout the presentation, is that in conjunction with that, we're still going to be asking every application, whether they're in a homeowners association or not, and if they are, that as part of the application submittal, they need a letter from their HOA. So we've got kind of a twofold checks and balances.
And the letter from the HOA would be from the board, some type of resolution, right? Because you do have multiple members on the board. You might have different points of view. You would need some kind of resolution that says that it's the majority of the board, correct?
Yeah, I guess so. Typically,
it's vary depending on the association. If someone submits us a letter and it claims that they are an authorized agent of an association, there is a self-certification of the application. So we have to kind of take it for the word of it too. So whatever legal action or legal document that association looks to is what we would accept.
Okay. I'm just saying, you have multiple people on a board and you want to make sure that it's the entire board that's voted on that as opposed to just an individual board member speaking on behalf of the board, right? Anyway, I think, yeah. So I've had my question answered, and I think anything that is done should be consulted with legal counsel for the HOA as well.
Absolutely.
I will lower my hand.
Marla, I see you. I'm going to ask you to unmute.
Sorry, I just have one more question. Where is the application found on the city website? Or is it not up yet? The brief one that you have, because I find the one that has a bunch of pages. I just want the one that you had up. Or is that not up yet?
I apologize. I thought it was up. If it's not up, it'll be up here in the this afternoon on that main short-term rental page. So we'll have it highlighted. You can see that there's a section associated with the coastal development permit for short-term rental HOA communities.
Yeah.
So it'll be in that section, and it'll be there before the end of the day.
Okay, because I was just on that page. So, all right, thank you.
Deborah? Oh, sorry, Deborah. I think you're muted.
There we go. Can you hear me now?
Yes.
Okay, great. Thank you. I have a question. You stated that the permit, if it's a one-time permit, but if a new board comes into play during an election year, and let's say the original board got the permit for the HOA's benefit to prohibit STRs, then the new board could actually go and start over and say, no, that's not going to be the way it is. And then do we have to reapply again the following year if a new board gets in place, or how does that work?
To then allow for short-term rentals?
Well, each board can conduct business as they see fit, since they were elected to the, the property board. So let's say my board originally, says, no, you can't do this. We're going to go ahead and get that file for that permit. And so if we get, because our CC&Rs specifically do state 30-day or more leases are required. So let's say a new board gets elected in next year, could that new board go in and change the permit or eliminate the permit that we have?
I guess foreseeably, yes. I think it's in the association's best interest to consult with their attorney associated with that, given that it could be contradicting their CC&Rs. So,
well, no, what I'm saying though is the permit itself. Is the permit something that we could, so let's say our CC&R state must be 30 days or more, any lease. And in our so no short term 30, anything less than 30 days. So if we get that permit and you stated that it's permanent, it's something we have. Let's say the new board comes into play and then they say, oh, we don't want to keep that permit in place. And then the following year, one, is that possible? And two, then let's say the following year, a new board comes on and says, okay, no, we want that permit back in place. Will you allow us to get another permit to counteract what was done the year prior?
Yeah, we are, like I said, at the beginning of this, our goals is to assist the communities with whatever their goals are and their desires are for their individual community. And so if those change, then we're happy to either rescind or reapply for short-term rental, or the prohibitions of short-term rentals. So yeah, we will be able to pivot if necessary to what a community's changed desires are.
Okay, so let's say then the previous, the original, we get the prohibition of the short term, and then the new board comes in and they get it undone, they unwind it, and then we can apply for another permit that would be taking effect. Is what you're saying. It's not a one-time only, it's something we can reapply, and there's no limit for HOAs. Is that correct?
Correct.
Okay, then my next question is, I've been doing research with insurance companies, and the HOA insurance liability companies, because of all the problems that have occurred, just with environment, fires, mudslides, rain, etc., flooding, the insurance companies are very strict in the state of California. I have researched this at great length, and the majority of them for HOAs will not accept anything. They do not consider anything less than 12 months. They look at anything that is less than 12 months as short term. It's their definition. They actually, and their label. So I can go through the list. I have probably 9 or 10 major grade A rated insurance companies that have stated they will not accept any leases under 12 months. This puts the HOAs in a very difficult position because they classify short-term leases under 12 months. Our CC&R state anything short-term under 30 days. And the city now is saying short-term is under 30 days as well, and they're issuing permits. But how do these HOAs get appropriate liability insurance when you have all these conditions? I checked to see what it would cost to get secondary insurance, and because they don't fall under the insurance commission, they can change rates and cancel as they wish. They're not monitored. So, and the prices are 3 times what it would be if you had a grade A rated insurance company that you've been with for a long period of time. So it seems like this idea is great, but it doesn't, the bigger picture wasn't necessarily completely thought out as to how HOAs are supposed to handle all these other situations, unless HOAs are going to fly under the radar with their insurance company.
So yeah, there's a couple of moving pieces there, right? One is the insurance and what's an acceptable rental lease term, and that's really separate from this issue. This issue is purely on just the renting of the short-term rental of a property, and with the association, whether they want to allow it or not. In terms of the insurance element of it, that's a separate issue, and whether the community wants to, it's separate issues.
Right. Yeah, but it does become very problematic for HOAs because it does raise the premiums. I mean, the least I found was 3 times. So whatever you're paying now, you can increase it to, dramatically. And so these short-term leases do become expensive, and not for the people that are doing it, because they're increased, although they do pay the dues, and then the monthly dues would be increased. But how far do you go? Because then you're going to outprice yourself compared to all the other HOAs who are not doing it. And then when you go to resell, if you chose to do that in your own individual property, maybe your monthly dues are going to be so enormous that you won't even compare to other HOAs on the same street. Yeah, these are just some things to think about. And I've done a lot of research on it. I've got plenty of homework notes that I've taken on this. And then my last question is the amount that you said you thought the permit would be reduced to. Did I hear 600? Is that what you said?
I think we're working on ironing out what the exact number is. It's going to be.
It'll be less than 500. We're still working on it though.
Oh, that's the one for the HOAs to be able to prohibit and coincide with their CC&Rs?
Correct.
Oh, less than 500. Oh, wow. That's so much better than what I heard it was the other day.
Yeah, our standard CDP fee is several $1,000s. So this is definitely a streamlined process.
Oh my gosh, that's great that it reduced so much. Thank you. Okay, well, I appreciate your time and all your work on this. Those were my questions that were at the forefront. So thank you.
You're welcome, Deborah. Next up, I see Mark. I'm going to ask you to unmute.
Hi, so I've got a question. I'm representing a HOA, and it was really around the appeals and being in the appeal zone, because it appears that our HOA is in the Coastal Commission zone, but not in the appeal zone. Does that just mean that we can't be appealed against?
Correct. You could not be appealed to the Coastal Commission.
We still need a CDP.
We're still recommending you obtain a CDP because you are still in the coastal zone, and so the coastal act still applies, and those court cases and the recent court decisions are still applicable.
Awesome, thank you.
All right. Does anybody else have any questions? I see Gma. I'm gonna ask you to unmute.
Hi, this is Diane. My son-in-law named me Gma. Sorry about that. Well, no. Recently we had someone purchase a home in our association, and we noticed that there were people that were in there for just a weekend or maybe 5 days at the most, new ownership. And my question is, does code enforcement help us out as an association if someone does not obtain a short-term rental application from the city for more than 30 days and decides to just go underground with the whole operation, reap the money, and then other homeowners view this going on? What's our recourse?
So code enforcement is the city's kind of arm to address these illegal short-term rentals. We also have a third-party company that monitors, I think it's somewhere around 35 online short-term rental platforms, and to track which ones have permits and which ones don't. And so I would say that if you do see any activity of likely an illegal short-term rental, definitely contact our code enforcement division, and we will be reviewing that clososely.
I'll like to add something. I may have talked to you, Diane, on the phone. The key is when we get complaints about an illegal short-term rental, what we do is we go on to the platforms, the advertising platforms like Airbnb or VRBO to see how they're advertising. What they do is they'll start advertising for 30 days or more. And as was mentioned, that's not considered a short-term rental as defined by the city. So in that case, it would not technically be a violation. So if we still have a concern that they are renting for less than 30 days, it takes some really keen detective work sometimes from our staff to do random site visits and see if we can get some observations that it actually is being rented for less than 30 days. So we definitely follow up on these complaints. Sometimes it's difficult to prove that there is actually a legal short-term rental occurring.
Is there ever a fine from the city?
Yes, there is, certainly. First, we'll send a notice of violation, and then there's fines that upwards can be at $5,000 per violation.
Thank you very much.
Do I see anybody else with questions? Please raise your hand if you do. All right, not seeing anybody. I do want to offer up that we will be updating our city webpage to include that application before the end of the day. And I am available if you do have any questions in the midst of processing an application or additional inquiries. I'm available to answer those questions and aid you through that process. So we are hoping to bundle whatever comes in probably by the end of March to go to that meeting in April, which is April 24th. So again, yeah, if you have any questions, feel free to call and email so that we can assist you with whatever you'd like.
John, looks like there's another hand coming up by Janet.
Yeah, I just have one question for just operation wise. Who in our HOA, should a board member come down and fill out the CDP permit, or do we do that online, or should that be our property manager?
Whoever's your authorized agent, whoever's legally obligated or can represent your association. As was mentioned, we don't want just any person coming down and not having the authority.
Okay. And we'll figure that out between our board, I'm sure. Okay, thank you.
Great.
All right, well, thank you everyone for joining. And again, this will be posted to the city's short-term rental webpage. And we appreciate your participation and good questions on working through this process.